Hello, Genevieve. How are you?
I'm well. How are you, Maya?
I'm doing very well, thank you. Very happy to see you and very excited to have this chat today with you because we will actually be talking about a very hot topic. I know it's probably not a very pleasant experience that you had. It was a bit stressful, but it was a very unique experience and situation that you recently experienced in one of your cases. And it was really something that a lot of um, articles and a lot of lawyers were talking about. So you're here to discuss the recent case that you had, where there were this threats of having a contempt proceeding go against you. So before we get into that, though, I would like you to introduce yourself to our audience. Where are you based? Where is your firm based? And what types of areas of law do you practice in, Genevieve?
Okay, my name is Genevieve Eliany. I've been a lawyer now for over 10 years. I practice exclusively criminal defense, and my early years of practice were in BC. They have a very different court infrastructure. And if anything, I'd say that that informs how I run my files here, and it definitely had an impact on just my style and the JPT and this contempt citation. So I was out there for 3 years and I came back to Toronto because I missed it, but I didn't end up staying in Toronto. I live and work in Hamilton.
Okay, and this is where you're currently based in Hamilton, Ontario. Okay, so before we get into the case, though, so you did mention that you have your background experiences in BC and that had an impact. In what sense did that have an impact?
The court system is a lot more efficient in BC. Everything is different. They have a Crown charge approval process. Technically, most of the time, you could request a trial date at the first appearance. Because when the Crown is reviewing its file to decide whether or not they'll prosecute it, they also do a brief overview in their trial estimate. So everything's ready to go from the very beginning. I'm sure that has changed in the busy jurisdictions, but there are no required Crown pretrials, and there are also no required judicial pretrials. Sometimes things would end up in case management, but JPTs just don't exist. Excuse me.
Mhm. Okay,
Uh,
so
they, I remember at one point we ended up in case management. There were a number of co-accused, and the file was just not moving forward. And the whoever is managing or hearing the case management is not removed from the pool, even if there's a JPT, unlike here. So anyway, because of those early years, I tend to receive disclosure, schedule the Crown pretrial early on, even if items are missing, and same with the JPT. And of course, I'm going to have an idea of strategy and pretrial applications and so on. But I'll often tell the judge, I'm not done my legal research. This is what I anticipate. This is the direction we're going in, and this is how much time I need. Because that's how we could do things in BC. We were never asked how many witnesses. We were just asked how much time we needed above and beyond Crown's time estimate. So it's very different. So in this case, it certainly backfired in this sex assault JPT that led to the contempt citation. But if anything, the way I move file forwards is what they're expecting under the new Jordan directive. So it'll be interesting to see how we manage some of the details that some judges insist on with efficiency and moving things forward when we don't have all the information.
all right. So talking then about this case, Genevieve, so you did indicate that it's a sex assault case, but was it like a complex one or was it just a regular sex assault case? Like, tell us a little bit about the background. I know you can't get into details of the case, but just in general, so that people who don't really know about the case just get an idea about the type of case it was and what happened at the JPT and that eventually led to the situation that you found yourself in?
As I see it, it's a normal sex assault. What will complicate that trial is that he was in an open relationship and there's a third or multiple parties, but specifically a third party involved. Those are always difficult pretrial applications and 276 applications. So I will have to spend a lot of time on drafting it. I explained it to the JPT judge, but he didn't understand the basis. So there was a dispute during the JPT. And, I wasn't asking for anything special. It's a 2-day trial. The usual, often we say 2 half days for the 276, or usually stage one is no more than an hour. I had also told him that there were anticipated text messages, but he was in custody, so I didn't have the text messages at the
Mhm.
time. So I, was transparent about that. I simply said, "Oh, I'm anticipating this," which has always been normal in JPTs. You can say, based on what I have now, this is the direction we're going in. But for some reason on this particular day, it wasn't enough.
And so, what specifically wasn't enough?
My explanation of the strategy and the basis for the application. I so once I was unable to explain the issues in a satisfactory manner, the memo was requested. I immediately refused it, and I was very firm about it. It wasn't an ambiguous refusal. And one of the reasons I gave was that sex assault litigation is already crushing on legal aid for defense counsel. It's so much work that we're simply not paid for because, at least in my applications, I'm often well beyond the tariff hours. So we didn't get into any philosophical issues or the role of the JPT judge or any of that. It was in the back of my mind, but JPTs are quick, right?
Yeah.
This was, I think, 9 or maybe the 9:20 slot.
And I wanted to ask you, though, on this point, the memo point, Genevieve, because I mean, you did mention that there are differences in BC versus Hamilton. So, is it a local practice in Hamilton in the JPT stage for the JPT judge to ask for a memo to justify why you're asking for a 276? Like, is it a local practice there, or was this
No.
unusual even for Hamilton?
Oh no, Hamilton, I'm told, is quirky. I've never had that happen before. I've often been very blunt and said, this is my intended strategy. I'm not done the research. It may be that it's abandoned. And judges have always been fine with that.
Right. I mean, and I guess the reason why you're bringing this and raising this issue in advance is just out of an abundance of caution so that later on, if you realize that you need to bring that application, that it's not too late, right? Like that's one of the reasons why even early on, if defense lawyers were not too sure about how valid that application is, we still bring it because, or say that we are going to bring it, and then we can abandon it. And so was that what the judge didn't want? Like he wanted to confirm that you had a solid basis for that application before he kind of consents to giving you the time for it?
Exactly. His reasoning, in my opinion, it evolved a little bit, very slightly, was that he needed to understand it to allow sufficient pretrial time. And I think that's a reasonable position if it's an unusual application or a special application.
Right,
But this is a 2-day trial, regular 276. It's pretty rare that a 276 will take more than an hour, sometimes 2 hours, but really they're quick. The stage one is vetting.
right.
And then the stage two, of course, can change in length. So he simply said that he needed to understand the basis. I think part of the background to his reasoning is that there is some case law against him where he encourages Crown, and there was also a prelim issue where he wants defense applications to be dismissed outright, summarily dismissed.
All right. And that was, I mean, I'm guessing you've appeared before this judge before. So was this something that happened also in the past, or was this the first time that you were encountering the situation with this judge?
I've never had any issues with him. Sometimes he gets a little bored and impatient, but that's just his character.
Right.
He usually has a good sense of humor and likes to keep things moving. He likes to cut to the chase. We haven't had any difficulties. If anything, the last trial I ran with him, I thought was an interesting one. It was an LSD file with an expert, and it was unusual as far as LSD prosecutions go. Um, no, I'd say that this is maybe something new that he has in mind.
And Genevieve, just going back to the point that you mentioned that you had experience practicing in BC. When did you move again to Ontario? When did you move back? Like, how long have you been practicing in Hamilton?
So I came back in to Ontario in 2016 and I moved
Okay.
to Hamilton. So it was November 2016, moved to Hamilton April 2017.
Okay, so you've been practicing in Hamilton for a while now.
Oh, yeah. I
Okay,
knew this justice as a defense lawyer. We didn't know each other well,
right.
but we knew each other. He was appointed, I think it was right before the pandemic, but he was sitting in Guelph for a while. He's also the bilingual justice. So
Oh,
um, I will certainly face him again with for French trials.
and for some of the critics, because you did have, so there are a lot of people who understood your position. But there are some people who were critical of your decision not to write the memo. And from their point of view, it's, well, you should have just simply complied with what the judge ordered. He wanted a memo. Why didn't you just do this? So I have two questions here is, well, first of all, how do you respond? What is your reply to that? And does the JPT judge actually have jurisdiction to order counsel to write a memo? Because this is, I'm keeping in mind that this is not your trial judge. So I understand trial judges, they often ask lawyers to write submissions or to provide them with materials, and we do that. But does the JPT judge, and I think like this is a question that was raised here, like, does he have that jurisdiction? And how do you reply to your critics who just say, well, why don't you just simply comply and just write that memo?
I was surprised by the number of senior counsel, and I would say that most of those people no longer do legal aid work, encourage the filing of the memo. And it was those who are in the trenches who were supporting me and really understood the issues. In my view, and I want to make clear, if a trial judge asks for written submissions, I would have no issue with that. Um, that's a completely different ballgame. But in this case, and I would say it's relatively frequent, a JPT judge will say, well, I disagree with your argument. I don't see any merit in your charter application or even the 276 application. And it succeeds at trial, right? A
Mhm.
JPT discussion is brief, it's meant to be candid, and is often conducted before all information is available.
Right. Right.
So let's say I had filed the memo and he had refused to allow pretrial time because he wasn't happy with the explanation, still didn't understand it, and that was that. So the client would lose an appeal route if it turns out at the end of the day that there was information that should have been raised at trial that couldn't be raised
Mhm.
because there was no 276. That would be the gravest concern. It was Law Pro Counsel's concerns in this whole thing. Um, I made my initial reaction clear. It's too much on legal aid. We already have to spend, at least I do, a lot of time beyond the tariff hours. And in my view, it is beyond the JPT judge's jurisdiction. I looked at the rules immediately after the JPT to be like,
Mhm.
can you order a memo? Like, what's
Right.
going on?
Yeah.
And it's quite clear that Crown has to file materials. It's permissive for defense. And again, we're just trying to complete a trial estimate. So there's no reason for defense to explain the nitty-gritty of its position. Defense just has to say, this is how much time I estimate. And then we get a trial estimate.
Well, and it is scary from a defense perspective because sometimes clients do want to have a trial and all the pretrial applications, even if there's clearly no defense, they have that right. They have the right to have a trial to let the Crown prove the case. And even if it seems like there is no merit to the argument or there is no defense. So it is scary here that we have to justify why we want to do everything because sometimes our clients do have the right to still have a trial, even when clearly there is no strong argument to be made. So, I mean, I thought that was scary from that perspective that you'd have to justify why you're doing this. And, because then it's like, well, so what? Like he has to plead guilty, like he shouldn't be proceeding. And it really scared, I think, a lot of members of the defense bar. But what I want to talk a bit more about now, Genevieve, is how are you feeling during this whole thing? Because it's a very unique situation. I don't think that there is any precedent or any recent case that at least I'm aware of where you can look back to another lawyer's experience and see how they dealt with this. So how are you experiencing this? What was going through your mind?
I was not overly worried. I can tell that it took a toll because I would wake up in the morning thinking about it. So clearly my brain was thinking about it during the night.
Yeah,
But during the day, it wasn't an obvious stress to me. There were moments like right after the citation in December, I thought, what just happened? I have to find a lawyer. Like, what's going on? So that was an interesting time. But beyond that, it didn't stress me in the way that it may have stressed others. I was really firm in my position. And I also, there weren't any consequences that I feared. Even, I wouldn't have lost my license over this, but if I lost my law license, I don't think that would be the end of the world. This is my second career. I come from a healthcare background, and I wouldn't be unhappy to go to healthcare, back to healthcare. So, you know, I was fine with it. The client is also extremely supportive.
that's
So I
that's good.
wasn't faced with an upset client. He, his first reaction was that he felt bad for me. I was like, don't worry. Like, this is an inconvenience to you. It'll work out on my end. So I was okay. It's also partly my character. Some people have remarked on my calm, and usually the
Yeah.
crazier things get, the calmer I get.
Mhm.
I was surprised that people could see that during the Zoom appearances, but that's tends to be how I handle things. I'm tired now. I can feel that effect now that everything's over.
Yeah.
So I'm sleeping a bit more, but it's been okay.
Well, I mean, we're glad that you're doing well and that, you were able to remain calm because it is a very stressful experience. I mean, you did mention that you've been practicing for quite a few years now, like 10 years. But I mean, I can imagine if this situation was happening to someone who's more junior, they would be really afraid and stressed out. And I mean, maybe they would have just complied with the judge's request for a memo or order for a memo.
That
Um,
was one of my biggest concerns. I thought, okay, I've been doing this for a little bit, and junior counsel would comply. It would potentially drive the burnout rate of legal aid lawyers who only do legal aid work.
yeah,
Um, I was astonished by the degree of support. And most of it was word of mouth because it was not driven by the CLA. There were senior members who all called their friends and it spread that way. But I was surprised by where the support came from and the extent of the support. The local Hamilton bar was incredible. They were really great. And as you mentioned earlier, I was not a member of WiCCD. I will admit that I tend to prefer co-ed groups. So I don't usually join female only or women's associations. Um, but I'm really enjoying it. It's a great listserv. It's like a parallel universe to the
Yeah.
CLA listserv. So I'm very happy to have joined WiCCD.
Well, so let's talk a little bit more then about how Wicked intervened. Well, there was no intervention, but there was some support. So if you can maybe expand a little bit on that. And I just have to say that we're very happy that you joined Wicked and you're a new member and that you were able to find it, even though it was through a difficult situation. But Wicked is there even for the happy moments of a defense lawyer. So tell us a bit, Genevieve, how did you feel Wicked support in this case?
At first, I was really amused because information was being leaked to me just as my situation was leaked to WiCCD from one of
Mm,
the listservs.
right.
And there were so many leaks that eventually I had to join to see
Hmm.
what was going on.
Yeah.
And of course, there were discussions between Scott Cowan, who was representing me, and the head of most associations, including WiCCD. But the support was fabulous because it was very much a grassroots support. Um, it was interesting to see the national support. Of course, the people who know me in Hamilton were very supportive, and there was an outrage locally. But it's not the same when you see an experience resonate with members of the bar across the country.
Hmm.
So it was just it was a good lesson for me in accepting help and support and being less of a lone wolf.
Right. And I guess that also helps, right? To know when you're facing a difficult situation or a stressful situation, to know that you have um, members of your profession and colleagues who are there to support you. And just to clarify that one of the ways that Wicked showed support, in addition to admitting you as a member, and we admit any female defense lawyer, it's many of our members who could log into the Zoom appearance, did that as Wicked members, and just were there to show their support for you. And I hope that that made you feel that you had a back, that you had someone there to support you.
Oh, absolutely. It was definitely part of the overwhelming support. And also the comments on the lift serve, it was like a
Yeah.
play-by-play. That was always great to see. It was also helpful to see the different perspectives. Um, there were quite a few angles that I had not initially thought of. So it was great. I liked the creativity and the warmth of WiCCD.
Well, and we like that you've joined us. And Genevieve, I wanted to ask you, this is your opinion. Do you think that gender has anything to do with this case? Like, do you think that the fact that you're a female had an impact, or was this something that any lawyer could have faced?
I think anyone could have faced it. I gave Scott Cowan really firm instructions that if there was intervention by WiCCD, that it should not be gender-based.
Mhm.
I wouldn't have wanted any association to take that position. We did file a certiorari, just to be clear on the procedure. That
Yes.
was filed, and it was focused on jurisdiction. So I don't think that the fact that I'm a woman had anything to do with it. I did not feel targeted.
Okay. And how, just to clarify, how did this situation ultimately resolve? Because you're no longer facing this contempt proceeding. So what happened in the end?
So it was a speak to for the underlying file, and we had filed the certiorari notice that morning. The argument was such that I could reelect without making the contempt issue moot because I my preference was to litigate it. So I filed the notice of reelection, and the justice took that as an out, which is reasonable. There's a lot of value in having both parties save face. So I respect that. And a lot of the senior members really favored that approach.
Mhm.
So once I reelected, he withdrew the contempt citation. Some have joked that apparently reelection is now a defense to a contempt citation,
Yeah.
but that's how it resolved.
Well, it seems like now more and more sex assault cases are going to superior court, especially to a judge and jury type of trial. And do you think that this case kind of confirmed that notion?
Yes, very much. At the time of the first JPT, I didn't have all the information. I didn't have the text messages. And once I had that information, judge and jury was a no-brainer. It's a very relatable situation that I think members of the public will appreciate and understand.
Hmm.
So it seems like our best bet now because sex assault laws are so messy
Right.
and juries can better apply their everyday perspective.
Right. And I wanted to ask you, Genevieve, now that the situation is over and you're no longer in this stressful ordeal, um, do you regret looking back at this, what happened? Do you regret what you did? Do you maybe tell yourself, oh, maybe I should have, just complied, or would you still have done the same thing?
Oh, I would do it again. I don't have any regrets. I hesitated to re-elect because there was a risk that it would
Yeah.
end litigation.
Yeah.
I have mixed feelings about that decision to re-elect.
Okay.
It would have been nice to have a litigated precedent because I do think this will happen again.
Hmm.
And apparently, based on what others have told me, I seem to be more fearless and I was in a good position to litigate it because I didn't really care about the outcome for myself. Right. Of course, I care about the client. I don't want to give that
Yeah.
impression, but it didn't matter to me.
Well, I mean, like that's what I find is really very interesting in your particular situation is that you were able to remain calm and that you weren't afraid of the outcome, that you were prepared to take that risk. And this is maybe something that I would like you to talk a little bit more about because this is what many junior lawyers are afraid of. Like when the moment they're in a difficult type of situation, they don't have enough experience to deal with it, they kind of give up on their position and they just go with the flow and with what they're being asked to do. So explain to us a little bit more about that, Genevieve, and how, like, have you always been this way, or is this something that your experience has taught you? And what would your advice be for younger lawyers when they are in this situation, not to give up if they really think that they have a valid point?
It's a difficult thing. There are lawyers who I really admire who came to me and said, I would have filed the memo.
Mhm.
And it was shocking to me that lawyers more senior than me that I look up to took that position and felt that way. Um, I think it is part character. If I decide that something is wrong, then I'll take a stand and it doesn't bother me to stick to it. I think we also have to remember as defense lawyers that we're not popular and we're not there
Mhm.
to be popular. We have a difficult job and it's one that involves taking sometimes just difficult positions for all
Right.
sorts of reasons. They can look bad or it's not ideal. So we certainly have a tendency to want to please and to want to be liked by our colleagues, but I'm sufficiently established that people know I'm quite reasonable and probably sometimes overly compliant. It depends on what the issue is, but I pick my battles and I prefer to run my trials that way compared to the lawyers who won't concede anything, right? In terms
Mhm.
of style. You have to stand your ground. And a lot of senior lawyers were really concerned for my reputation. And they would tell me, you have to purge, you have to write the memo, you have to purge because it'll protect your reputation. And I couldn't understand that because if anything, a lawyer is meant to stand up
Mhm.
and to stand their ground. And I would ask them, okay, well, what's going to happen? Tell me, like you're going to have to spell it out for me because I'm clearly not understanding the social dynamic here. And the one concrete example someone gave me was about a senior lawyer who's generally unlikable. I think he was in Toronto and he was taken into custody. And the inmates, of course, were like, what's going on? Like, what are
Yeah.
you doing here? He was in his suit. And it was the best thing for his career after that. And I was like, well, this is not a good example of how it'll be
Yeah.
so disastrous for me. I think they were just concerned about judicial opinions and maybe perception by Crown. There were a number of Crown Counsel who wrote me privately to express their support.
Mhm.
I was not expecting that, but they did.
And that's very nice.
Oh, yeah. The amount of emails and calls that I received, like I said, was astounding. At the end of the day, as a young or senior lawyer, you have to live with yourself. And I would not want to see justification for trial time as a requirement for a case to move forward.
Right.
That's a really scary precedent to me. So there was that, and also to some extent protecting new lawyers who wouldn't stand up.
Well,
But apparently older lawyers do.
I think that's a bit of the kind of dilemma that we're in, the problems between Jordan and the requirements to move the cases quickly through the system. But that comes sometimes at the expense of the quality of the work that we have to do as defense lawyers. And it's kind of, well, if your case is, I mean, again, what I find is very scary here is that, well, you have to kind of tell them what your strategy is and kind of give your defense. And as defense lawyers, we always don't like to tell what we're planning on doing. That's one of the things that defense has as an advantage. And it's also just that, like sometimes again, clients may have zero defense, but they have the right to have a trial. So it's this speedy trial concept versus, well, but the right to have the trial in the first place. So, I mean, the issues that were raised in this case are this situation were really interesting. And I don't think too many of us really thought about them before.
Exactly. JPTs can be really useful for resolution,
Mm-hmm.
but as far as trial estimates, they're just an extra administrative step for us. And I'm not someone who brings frivolous applications.
Mm-hmm.
All the judges know that. So I can see maybe some lawyers bringing all sorts of frivolous applications, being faced with that kind of issue and the judge pushing back. But at the end of the day, as you say, Crown has to prove guilt. The
Right.
client could do nothing, could be a self-rep and do nothing and still be assigned trial dates.
Right.
Pre-trial time estimates at the end of the day are a courtesy to the system because some people recommended this. I would never recommend it or do it. They suggested that I could have abandoned the 276 at the JPT stage and then just brought it at trial because we can do that, right? We can
Right.
bring the 276 at trial.
Which could also be risky as well and irritate the trial judge, who is the ultimate decision maker in the case.
There's that. Socially, for sure, it
Yeah.
would piss off the trial judge, but it also makes a mess of scheduling.
Yeah.
Everybody loses their trial rhythm. And most of all, it would be going against my word. If I say that I'll do something, I'll do it. And if I say that I won't do it, I won't do it. Like it slices both ways, right? So I didn't want to be sneaky that way at all. I think a lot of crowns were appreciative that it wasn't being raised at the trial stage. You're like, well,
Yeah.
if you raise it at the JPT, then what are we doing? Right?
Yeah. And Genevieve, did this make you want to go back to BC and practice there, or are you, or is this just like a one-off?
No, I miss the quality of the work in BC.
Mm-hmm.
I miss the efficiency of the system. Um, I'm French Canadian, so it was too Anglo for me out there. I just didn't adapt socially. People would see my name and be like,
Yeah.
like they had no idea I
How
was
to
a
pronounce?
complete
Yeah.
alien.
Yeah.
And the mountains felt very much like a real barrier, and they were. I was in rural BC, and the highways were often closed in the winter.
Mm-hmm.
So if you were lucky, you could fly out, but It's an experience that we're not used to here. The worst case scenario in the GTA, I'm originally from Ottawa, is that you get stuck on the highway for a little bit,
Yeah.
but you're not actually stuck. So no, I wouldn't
Yeah.
to BC. I don't foresee leaving law anytime soon, but I would potentially go back to healthcare.
Okay. So
Yeah.
that's something that you're thinking about now.
It's always been an interest of mine. I didn't really enjoy clinical practice, but it remains a hobby and a focus. So, yeah, probably towards the end of my legal career, I would likely go back and do some sort of like nutritional counseling or something like that.
Well, Genevieve, I'm very happy to see that you're still very calm and that, like it's really very impressive here to see that how you weren't afraid and that you were prepared to face the situation with grace and a lot of calm. And this is really something that we all aspire to, right? Like this is how we have to be facing difficult situations. It's by being calm and not, like getting more irritated as the situation becomes more and more intense. I want to thank you so much for taking the time to share this experience with us and to, tell us a bit more about what was going on and how you were feeling throughout this whole situation. Congratulations that you don't have to deal with this anymore. And I wish you the best of luck with the trial with your new, election. So this is going to be a jury trial.
Yeah.
And best of luck for you and your client. And hopefully, this will be a good lesson for everyone in the future.
I hope so. Thank you very much. And thank you especially to Wicked and the executive and to anyone else seeing this who supported me because I very much felt supported in a way that I did not expect. And that was a great thing.
And we're happy to be there for you now and for as long as you're a Wicked member. So thank you for joining Wicked.
Thank you. Have a great day.
You as well.
Bye.